With that, we recognize Mr. Cannon.
Thank you, Mr. Chairman and Mr. Cummings and the members of the committee for the opportunity to present my views on the Internal Revenue Service's final rule concerning premium assistance tax credits in the Patient Protection and Affordable Care Act. I submitted written testimony on behalf of my co-author, Professor Jonathan Adler of Case Western Reserve University School of Law, and myself. It is our contention that this rule exceeds the IRS's statutory authority under the PPACA and is an illegal tax increase. Two facts are key to understanding why this IRS regulation is illegal. First, both sides of this controversy acknowledge that the statutory language governing eligibility for tax credits is clear and unambiguous. The Act provides that taxpayers are eligible for tax credits if they purchase a health plan through, quote, an exchange established by the state under Section 1311, end quote. That language clearly authorizes tax credits only in state-established exchanges, and the Act employs or refers to that language no less than 6 times when authorizing tax credits. There is no parallel language anywhere in the statute authorizing the IRS to offer tax credits through federal fallback exchanges established under Section 1321. The Act's authors intentionally condition tax credits on states establishing exchanges as one of a number of large financial incentives designed to encourage states to implement the statute. Even Professor Jost acknowledges that the provisions authorizing tax credits, quote, clearly say, end quote, those are his words, clearly say, those credits are available solely through state-created exchanges. Second, the remainder of the statute and the legislative history support the clear meaning of those provisions. The only statement anyone has found in the legislative history on this point comes from the bill's lead author and chief sponsor, Senate Finance Committee Chairman Max Baucus, who confirmed the bill conditions tax credits on states establishing an exchange. And yet, contrary to the clear language of the statute and congressional intent, this IRS regulation purports to issue tax credits in states that do not establish an exchange. Under the law's employer mandate, those illegal tax credits will trigger an illegal $2,000 per employee tax on employers and unlawfully appropriate hundreds of billions of dollars to private health insurance companies in states that do not establish an exchange. Since those illegal expenditures will exceed the revenues raised by this rule's illegal tax on employers, this IRS regulation will also increase federal deficits by hundreds of billions of dollars, all contrary to the clear language of the statute and congressional intent. This IRS regulation is a large tax increase. It imposes a $2,000 per worker tax on employers and obligates taxpayers to pay for hundreds of billions of dollars of subsidies to private insurers. For every $2 of unauthorized tax reduction that will result from this IRS regulation, it imposes $1 of unauthorized taxes on employers, commits taxpayers to pay for $8 of unauthorized subsidies to private insurance companies, and increases federal deficits by $9. Though this IRS regulation is nominally about tax credits, government spending accounts for 80% of its budgetary impact. Worse than a tax increase, though, this IRS regulation is an illegal tax increase. It lacks any statutory authority, it is contrary to both the clear language of the Act and congressional intent, and it cannot be justified on other legal grounds. It is quite literally taxation without representation. As you listen to the IRS and its defenders say that this illegal tax increase is consistent with the statute, or supported by the statute, or recognized through the statute, notice what they are not saying. In the years since the IRS proposed this regulation, they have not cited a single statutory provision expressly authorizing the IRS to do these things in federal exchanges, because there is no such provision. They have not cited a single statutory provision that conflicts with the language limiting tax credits to state-created exchanges, because there aren't any. Nor have they cited a single statement from the legislative history that supports either this regulation's attempt to issue tax credits in federal exchanges or their claims that it was Congress's intent that the Patient Protection and Affordable Care Act would do so. There is simply no plausible way to argue this IRS rule is consistent with or supported by congressional intent, much less the statute. The most important indicator of congressional intent is the text of the statute itself. That text is clear. It was there for all to see before Congress approved it. It is not possible that someone who read the bill could have mistakenly thought that that language authorized tax credits in federal exchanges. The IRS should rescind this rule before it takes effect in 2014. Alternatively, Congress and the President could stop it with a resolution of disapproval under the Congressional Review Act. And finally, since this rule imposes an illegal tax on employers in states that opt not to create a health insurance exchange, those employers and possibly those states could file suit to block this rule in federal court. Thank you.